Fireworks from court as movie producer Harvey Weinstein uses his walker to again head to trial for jury selection on 5 sex crimes charges in New York. Our team breaks down everything that happened in the biggest criminal prosecution of the Me Too movement. Welcome everybody to the Daily Debrief here on the Law&Crime Network. Harvey Weinstein faced a stern warning from the judge for using a cell phone in court today, and that's not all. Let's go first tonight to Law&Crime's Jesse Weber, who was inside the courtroom.
What an explosive second day in the Harvey Weinstein trial, and we haven't even seen opening statements yet. This is still in the jury selection process. Now, to set the scene a little bit, I was in the courtroom. I was in the front row right behind Harvey Weinstein. Now, the court rules do not permit cell phones, but I saw him actually using 2 cell phones before the judge entered. I thought it was a little strange. Well, I wasn't the only one who noticed. One of the court officers actually yelled at Harvey Weinstein and said, "Put it away." Now, the minute Judge Burke entered that courtroom, before he even put his robe on, he started yelling at the defense for Harvey Weinstein using his cell phone. Apparently, he is a repeat violator of this. This is when things turned chaotic. At one point, Harvey Weinstein even suggested and tried to explain himself away. The judge said, "Sir, I recommend that you invoke your right to counsel and remain silent." The judge said to Harvey Weinstein, "Don't answer this question. But do you want to spend the rest of your life in jail for using a cell phone?" As you can imagine, the Los Angeles indictment that was released yesterday against Harvey Weinstein came into play. The state made a motion to have Harvey Weinstein's bail conditions revoked. In other words, that he would be thrown in jail. They made the argument that he's a continued risk. He's a man of means and just a further danger to the community. The defense said there is no arrest warrant out for Harvey Weinstein in regards to the LA charges. Nothing has really changed. And the judge seemed to agree with the defense. The bail conditions will remain the same. However, he made the point once again and said to Arthur Aidala, if he violates any of those conditions, it's on you, Mr. Aidala. You may not be the one who's thrown in jail, but it's on you. Now, the final big issue today, also concerning the LA indictment, is can we get a fair jury? Arthur Aidala made, I would say, a 5 to 8 minute impassioned argument for why this case should be adjourned. In other words, a postponement. His argument was that this new indictment in LA ultimately taints a potential jury pool, that it's going to be impossible to not understand or see what happened in the last 18 hours. In fact, he took out 354 pages of articles that were released in the last 24 hours. He made the statement that he was out to dinner last night and people at a table next to him were talking about Harvey Weinstein. He also seemed to imply that there was coordination between the New York prosecutors and the LA prosecutors on this. In other words, saying that they attempted to taint a jury pool by portraying Harvey Weinstein in the worst of light, showing that he's continually a predator, and therefore more likely he'd be found guilty. It was a strong argument to make there to suggest that ultimately this trial should be delayed. The judge did not buy it. He said if you have problems with that LA indictment, then what you should do is you should question these jurors during voir dire about that. It's going to be very hard to get an impartial jury in the Harvey Weinstein trial, maybe now more than ever. This is Jesse Weber reporting for Law&Crime.
And though there are more than 80 accusers against Weinstein, this prosecution involves criminal charges related to only 2 women. Former Weinstein Company production assistant Mimi Halle says Weinstein forced oral sex upon her in 2006 at his New York apartment. An unknown accuser, whose name is not on the court record, says Weinstein raped her in a hotel in 2013. As to the first accuser, predatory sexual assault is the most serious charge with a possible life sentence. Next, there's an accusation Weinstein committed a criminal sexual act in the first degree. As to the second accuser, there's 1 count of predatory sexual assault again, 1 count of rape in the first degree, and finally, 1 count of rape in the third degree. The last charge is for an alleged victim who could not give consent to sexual activity for a reason other than being underage. Attorney Gloria Allred represents several of Weinstein's accusers. Outside court, she talked about the complications which will result from charges filed just yesterday against Weinstein in Los Angeles and how her clients are hoping for justice sooner rather than later.
I can't speak for the DA's office as to why they did it yesterday in LA. But from Mr. Weinstein's point of view, is there ever a good time for the Los Angeles County District Attorney to file 2 felony charges against him? Probably not. But this case is not just about Mr. Weinstein. This case is also about individuals who allege that they were victimized by Mr. Weinstein. And so, from the point of view of certain victims, my sense of it is they would like this trial to proceed and not be delayed. Let's get this done. Let's get it done in a way that's fair to Mr. Weinstein, but also fair to the persons who are going to be witnesses and who are going to testify. They're going to take the witness stand. They're going to be probably brutally cross-examined by the defense. Let's move on with this and get it done. And then after that, we don't know how long it will take to get to trial in Los Angeles. I mean, I've been practicing in California for 44 years. A defendant has a right to a speedy trial there and everywhere. It's a constitutional right. But sometimes defendants would not like to have a speedy trial. They would like to delay.
We also have a look at the 16-page questionnaire each member of the jury pool will complete. The questionnaire asks if each potential juror knows a crime victim, but never once asks for opinions about the Me Too movement. There are only a few questions about pretrial publicity, including this one. The defendant, Harvey Weinstein, is a film producer. This case has been widely publicized over the last year, including extensive, in-depth coverage of prior proceedings in this matter over the course of the last year. Can you assure all parties you will determine this case based only on the evidence you will hear in court? Attorney Alan Turkheimer is a jury consultant with a background in psychology. He joined us recently on the Law&Crime Network to discuss the process of selecting an impartial jury and then steering that jury toward a verdict.
Jurors are going to be asked about what they've seen, what they've been exposed to. So the more they talk about how they're embracing the Me Too movement, the more they're seeing all these things that the attorneys are talking about, the less likely it is they're going to get on a jury, and the more likely it is a defense can make an argument. Look, we're running out of people here. Nobody can come in with a blank slate. All the jurors are going to be summoned over the next week. They received their summons in the mail. They were told not to pay attention to the case. And look, some of it's going to seep in. They're going to get some of the big picture information. They know what's going on. They know that Harvey Weinstein's being charged and all that. But I don't think they're going to pay that much attention to all these interviews and some of the maneuverings that are happening. I think you just have to get the jurors to focus on the specific facts, the evidence, and try to look at the broader picture and try to have them come away with some sense of why some of these victims might be saying what they did. Maybe it's possible they had a different interpretation. I think they have to wrap their perspective in the law and try to get the jury to have disconnect between all this other stuff over here, this bad stuff, these accusations, and the specific words and recollections that these witnesses are testifying to. It's not easy.
Let's go now to our panel of experts tonight. Attorneys Dina and Michael Bryant are here with me, along with Judge William Dawson from East Cleveland. So, Judge, bring us into the mind of the judge in the Weinstein trial. We know he was irate over the cell phone issue today. What else could he possibly be thinking as this case moves into jury selection?
You know, the judge at this point is really concerned about keeping order in the court. I mean, to be honest with you, just the fact that he would use the cell phone, even though they know that that's a rule, is showing that there's going to be a spectacle. So he has to lay down the law very quickly to establish that he's not going to go for any of those outbursts, any disrespect, or any attorney or the defendant himself deciding to do what they want to do in his courtroom.
Let's move on now to another issue that I think we all want to talk about tonight. Dina, does it surprise you that there are no Me Too questions in the jury questionnaire itself, the written document jurors have to write out answers to when they first go into that courtroom?
It's a little bit surprising because this is maybe the most famous of the Me Too movements. I think the way that question was worded actually made it very easy to say, yes, you can be unbiased. A broader question about how you feel about the Me Too movement in general would have probably gotten a lot of more vague answers from the jury members, and maybe that's what they were trying to avoid.
Well, look, I mean, maybe they want a jury that says, I don't even know what the Me Too movement is, Michael Bryant.
Yeah, good luck with that. Yeah, I think you really don't want to ask closed-end questions in that jury form there. Yes, I can be unbiased. Really? Does that tell you anything? Are you going to believe that? If you don't go further, I'd be looking at people who say, no, I can't. And then I want to explore with them why they think they can't. I think it's a mistake to make a question so closed-end.
Judge, what do you make of this? Much has been raised of the issue of the Me Too movement here. Do you think it's possible the judge might have said, hey, look, I don't want that question in the questionnaire? And if so, why?
It's very possible, because think about it, with these questions that are presented, the judge does get a chance to look at them and see if there's something that he disagrees with. So I would assume, just a good bet, that if there's no question about Me Too, it's a good chance that was run past the judge and he made some type of ruling, because I would think that there would be something, just something in there. But then again, just like Dina said, you may want to keep it open so that it doesn't get right to that vague answer of yes or no, I disagree or I agree with the movement. So they're both sides to it, but I think maybe the judge had something to do with that.
And quickly, Judge, what do you think of the verbiage Me Too coming up in this trial? Should the attorneys go there? And if so, why not?
If I was defending this case, I would ask for it not to be mentioned in the trial. I would ask for a meeting with the judge or on that issue alone. We would have sidebars, we would have motions. I would do everything I could to make sure that wasn't brought in, just because it has such a stigma to it, and it rings of a certain type of character when you hear that word and that phrase. So that's what I would do as a defense attorney.
Certainly. Let's move on to another case we're covering right now. Connecticut authorities announcing murder charges today against a wealthy man suspected in his wife's disappearance. Fotis Doulos is accused of capital murder, that's life in prison in Connecticut. Girlfriend Michel is accused of conspiracy to commit murder. In court documents today, Triconis told authorities that Fotis Doulos told her, sometimes I hope she disappears, with reference to wife Jennifer. Also new today, an attorney said to be an old friend of husband Fotis Doulos has also been charged with conspiracy to commit murder in Jennifer's disappearance. And still ahead here on The Debrief, a shocking opening statement in an Ohio trial. Lawyers for a mother admit she murdered her infant during opening statements. We break down the strategy for that statement after this break. Let's go now to Ohio and the trial of a mother and father accused of killing their infant. Jessica and Daniel Groves face a series of charges in the death of Dylan Groves. The defense said he died on March 28th. That's 2.5 months after everyone admitted he was born hooked on drugs. Authorities say the little boy was murdered, wrapped in plastic bags and duct tape, and then put in milk crates bound by chains, padlocks, zip ties, and wires. That so-called coffin was weighted and thrown in a well. We're going to play the opening statements out of sequence because of this bombshell from the defense for the mother. She, through her attorney, promised to testify and admit in front of the jury that she was the killer.
My client, Jessica Groves, was and still is a drug addict. She, and she alone, caused the injuries to Dylan Groves, which led to his death. She murdered Dylan Groves. She will testify that she murdered Dylan Groves, to the injuries that she caused to Dylan Groves. The 2-inch fracture on the skull, the 1-inch fracture on the skull, the 1/2-inch laceration on the left arm, fracture of the left humerus, fracture of the left radius and ulna, red contusion on the right side of the chest, and the drugs in baby Dylan's system. You might ask, why put everybody through this ordeal? The answer is because she's going to do the right thing right now. And that right thing is to take personal responsibility for her crimes and sins. And that right thing also is to protect and defend an innocent man. Daniel Groves had nothing to do with the death of Dylan Groves and did not cause these injuries. He was foolishly unaware of these injuries. Dylan Groves died on March 28th, and Daniel found him unresponsive. Once he found him, panic and confusion set in. And with that panic and confusion came poor decisions. That leads us all to here today. Did he help hide the body? Yes. Did he suggest the well? Yes, he knew where this well was. Did he help craft a coffin and preserve Dylan? Yes, he did. But that is all he did.
That defense turned this case into a trial about the drugs, which the defense for Jessica Groves said were a serious epidemic there in Portsmouth County, Ohio.
and has devastated our friends, our family, and our whole community. It is no respecter of age, status, or wealth. This scourge of our modern society turns spouses against spouses, siblings against siblings. Grandparents are raising grandchildren, and in some cases, great-grandparents are raising great-grandchildren. There are so many people trying to reverse and correct this problem. There has been this upswell in our community of people that have said enough is enough. We're going to change and come back. But the first step in winning this fight is for individuals that have been led down this path to take personal responsibility for their crimes and their sins. And that starts right here, right now.
The defense attorney for the father told the jury that Daniel Groves only helped dispose of the baby's body. That attorney said the father cooperated with police because he finally couldn't lie anymore.
He led them to where Dylan had been placed. He did not cause his death. He never kidnapped him. He never caused his death. He never endangered him. He never interfered with custody. He never caused harm to this child. He cannot be the source of felonious assault that he has also been charged with, and that's what I want you to listen for. And it is our position that that will not be proven by the state. That will be accounted for by the actions of Jessica Groves. We anticipate her telling you in her own words how, whether you call it my client was blind, whether you call it that he was foolishly unaware, he may have been, ladies and gentlemen, but he had no knowledge, he had no participation, and he was not the source of the injuries that resulted in Dylan's death.
Before the defense attorneys gave those opening statements, prosecutors described the troubling birth of victim Dylan Groves.
Not long after birth, baby Dylan was taken to the nursery and put on oxygen because he was born early and needed support. The testimony will be that neither parent accompanied that baby to the nursery, and both Jessica Groves and baby Dylan had positive drug screens there at the hospital. Within 12 hours, baby Dylan begins to exhibit symptoms of drug withdrawal. Baby Dylan's U-cord, or umbilical cord, showed positive for methamphetamine, amphetamine, fentanyl, and opiates, including morphine. On January 15th, 2019, Andrea Bowling became baby Dylan's foster mother as she picked him up from the hospital. On January 16th, 2019, Scioto County Children's Services awarded emergency custody of baby Dylan to Children's Services.
Baby Dylan went back into his father's care and lived with his mother, Jessica, too, for a while. Prosecutors say Jessica and Daniel failed to comply with child services, failed to stay off drugs, and failed to stay employed.
Deputies of the Scioto County Sheriff's Office attempted to make contact. Captain Murphy and Chief Miller from the Sheriff's Office attempt to make contact. They see the defendants on the roadway near their home and attempt to stop them, and a pursuit ensues, and the four-wheeler they are on flees off the roadway into the woods. Juvenile court sent an employee to make contact. Finally, the Sheriff's Office obtains a search warrant for that Mount Hope residence. And on June 10th, 2019, several members of the Scioto County Sheriff's Department, the Southern Ohio Drug Task Force, and the Ohio State Highway Patrol surround the residence on Mount Hope Road, demanding that Jessica and Daniel surrender. You will hear that Jessica Groves maintains that Children's Services has come and taken her baby. Evidence will be that Daniel Groves is dope sick in there during that interview, rolling around in the floor. Evidence will also be that he tells several stories, starting with Children's Services came and took the baby. But eventually, Daniel Groves admits that baby Dylan is dead. Eventually, Daniel Groves leads the Sheriff's Office to a spring-fed well, 40-foot well, in the middle of a hayfield. It took several men to pull the container to the surface. These two plastic milk crates chained together, zip-tied, and wire-tied. It was weighted down with several rocks and a round metal object around Dylan's body.
Dina and Michael Bryant are back now with Judge William Dawson. So, Judge, it's important to remember that those prosecution openings came before the startling admission from the defense. But I got to ask you, when you're presiding over a case like this where the defense attorney admits to a murder charge, how does that change everything in the courtroom?
You know, there's almost like a hush goes over the courtroom. You're really in shock that it just happened. What I would do is I would really call a sidebar really quickly and have the attorneys come up just to make sure that we are all communicating and that everyone's of right mind and sound mind before we go forward. Because really that is a shock, because otherwise you would think if that was going to be the case, we wouldn't even be in trial today. So it definitely is a shocker that I would have to address as a judge.
Oh, certainly, and that is exactly what the judge in this case happened. So judges think alike here, ladies and gentlemen. Dina, we have aggravated murder here. That's a mandatory life sentence in Ohio, but it could come with parole eligibility after 20, 25, or 30 years. Then we have murder itself, which is a 15 to life range in that state. Is the defense for the mother hoping to maybe go for lower sentencing ranges, maybe get that chance at parole? Is that the strategy here?
You know, I have to say my opinion here is that there is not a legal strategy here, that maybe this is what we're seeing is how illogical and dysfunction this disease of addiction really is. It kind of reminds me of how much effort the parents put into putting the baby into the well. And then the father just went ahead and admitted where the location was. It feels very disjointed and dysfunctional all along. She's saying there's a defense, and then last minute she's confessing to it. I don't know if there is a strategy here.
Or the strategy is to try to save the husband because he has at least one other child here. So Michael Bryant, should the state roll along with this and go along with the admissions, just sort of back out and say, hey, look, we're going to take all this as it comes? In doing so, the state would have to drop the charges against the husband, though. Should the state do that, or does the state go at the husband and say this foolishly unaware of injuries, which then showed evidence of healing? He couldn't have been foolishly unaware. Does the state still go full throttle?
I think they really have to go full throttle at this point. I wouldn't want to leave to this opening statement the ultimate impact of who gets charged and who gets convicted of what. I would want the jury to deal with it.
And if the jury believes the defense in this case, the husband gets off with third-degree and fifth-degree felonies, which are drastically lesser punishments than those murder charges, Michael.
Yeah, exactly. I mean, that makes my point. I think at this point, you got to go forward. You got to finish the case.
And the deal was probably a bad deal for the defendants. That's why the case is going to trial. Thanks a lot to the panel. We're out of time. We'll see you back here tomorrow at 5 p.m. on The Debrief.